Assalamualaikum warahmatullahi wabarakatuh. Today we're going to have a look at the new topic. The topic is agreements in restraint of trade. The topic is quite, okay, let me just maximize. Okay, all right. So the topic is not that long, that long compared to the bulky topic that we have covered earlier on. So for today we have this topic. So let's have a look at the definition of the terms or the phrases restraint of trade. Because in some situations, in some circumstances, there could be a contract in which it contains certain clauses, and then the effect of the clauses is that to restrain the freedom or the liberty, right, for a party to do whatever he wants to do in the future or later. So when we talk about the contract in restraint of trade, actually it refers to the contract by which a party restricts his future liberty to carry on his trade, business or profession in such manner and with such person as he chooses. So meaning that here, if the provisor signs the agreement, signs the contract, so he agrees, he promises that his future liberty is being restrained, is restricted. So this is in relation to his trade, his business or profession. Meaning that here, if he signed the contract, he promised or he agreed not to carry on certain profession or certain business or certain trades. Okay, it depends very much on the specific clause itself. So when we look at the nature of the contract, actually there are altogether at least generally there are four kinds of contract where such clauses of restraint may exist or can be found. So we have at least four here. The number four is the catch-all clause or safety net. Okay, the first one, which is most common one, is contracts of employment between employer and employee, because usually employer will impose certain restriction on the employee even after the employee leave the employment. So it's possible. So we want to know whether such clauses of restraint are valid or enforceable or not. And then the second situation is contracts between vendor and purchaser for the sale of the goodwill of a business. So if the vendor is selling his goodwill of the business to the purchaser, so purchaser might impose certain restraint on the vendor. Okay? What is the meaning of goodwill here? The easy meaning, okay, the plain meaning is goodwill means reputation. Okay, goodwill of the business, reputation of the business, good names of the business here. We are going to discuss later. Okay, what is the effect? Is the clause enforceable or valid or not? And then the third situation is contracts between partners. So it involves partnership, usually legal firm or professional businesses, okay, professional arrangement, okay, trades between the parties. So it is established based on partnership. So this restraint may exist in clauses in respect to prior to dissolution of partnership, just before they dissolve partnership. So whether they can restrain each other. And then as well, the restraint clauses here can also be found during the continuance of the partnership. So is it possible for a partner to restrain other partners, okay, from involving in other business, for example? And number four, okay, whatever commercial contract which is not caught by number one, number two, or number three. So it falls under number four, okay, fourth kind of fourth type here are the commercial contracts. So as far as the topic is concerned, we only have one specific section, okay, which governs all the situation or the principle here. So the section here is section 28 of Contracts Act 1950, and I reproduce the provision here. You can actually refer to your own Contracts Act. Okay, for example, I have with me here the compilation of the statute. So my section 28, okay, you can have a look at the section 28. Okay, it says here, every agreement by it has two parts. Okay, here it has the general rule, and it also has a longer part, which is actually the assumption. Okay, it used the word saving of agreement. So we have a look at the general rule here. Every agreement by which anyone is restrained from exercising a lawful profession, trade, or business, okay, of any kind is to that extent void. So the important keyword here is every agreement, restraint, and void. So the effect is that it is void. It's not valid. It is not enforceable whenever the agreement has the effect of restraining the party from what? From doing what? From exercising a lawful profession, a lawful trade, a lawful business. And then this rule, section 28, it comes together with a long assumption. It has three assumptions here. It starts with the word saving of agreement. Meaning that here, the agreement is being saved. It's not, we don't apply the rule just now, in which it says it is void. But in this assumption 1, 2, and 3, the agreement is valid despite it contains the restraint. Okay, the first one, saving of agreement, not to carry on business of which goodwill is sold. So whenever it involves selling of goodwill, so it's possible for the purchaser to restrain the vendor. Okay, all right. And then for exception 2, saving of agreement between partners prior to dissolution. So they are about to dissolve, okay, the partnership, and then prior to dissolution, the partners can still be restrained, cannot be involved in any other businesses. And exception 3, saving of agreement between partners during continuance of partnership. So they have to really give their all, okay? Not, I mean, they have to really serve the partnership, okay, without being involved in other businesses. It can be restrained in that respect, in that sense. So now we want to know how to interpret section 28. Because why? It contains the word all, every agreement. So what is it? What's the meaning here? Does it include all agreements which contain restraint clauses? So a strict interpretation of section 28 would give the effect that all covenants in restraint of trade void, even if the covenant in question were reasonable. Because if we were to read the phrases which contain restraint, maybe in some situation it is reasonable, it's okay to restrain those person in that situation. It's reasonable for them to be restrained. But if we were to apply the strict interpretation of section 28, whatever agreement containing restraint clauses, they all become void. So now we are going to look at some of the Indian cases from Indian case law. Why? Because our Contracts Act actually is in pari material with Indian Contracts Act. Okay, we have at least two cases here, Madhub Chandur and Rajkumar, old classic case 1874, reported in Bangalore Law Report. And in this case, the court held that every covenant in restraint of trade was void under section 27, which is equivalent or in pari material to our section 28, Contracts Act 1950. And in another case, the judgment by Supreme Court, the case was Superintendent's Company of India, Private Limited, and Krishnan Mugai. This is 1980, not that classic compared to the first one, okay? So why we are referring to this case? Because Supreme Court in this case considered in detail the scope of section 27 of the Indian Contracts Act. That's why it's very relevant to our topic of discussion here. So in this case, Supreme Court held that the position of section 27, which is actually our section 28, was different from that under common law. Meaning that here, on that part, okay, on that issue, our law, Indian law, Malaysian law, they are different from common law, because in most of the situation, we follow, we refer, we adopt the common law. But on this part, okay, in this area of restraint, we don't apply. It's quite different. Okay, the rule is quite different. Okay, so in this case, this quotation from the judgment here, the court stated, A contract which has for its object is the aim, the objective of restraint of trade is prima facie void. And Section 27 of Contracts Act in general, general in term, it is very general in terms, unless okay, a particular contract can be distinctly brought within a section 1, okay, or even 2 or 3. So there is no escape from the prohibition. So the prohibition covers almost all contract except whatever fall under section 1, 2, and 3. Okay, let's have a look at our local case in which section 28 was applied. This is a case, High Court case. The judge was Hasim J. So he held that under section, this is 1964 case, see? Under section 28, English decisions relating to restraint of trade were not relevant because why? The council was trying to bring in the common law cases, okay, to be applicable, and then read together with section 28. Because why? All covenants in restraint of trade were void under section 28. And then the court said test of reasonableness could not be applied in such cases, even though the council tried to persuade the court to apply test of reasonableness, because maybe the clauses, the phrases, the restraint clauses are reasonable. So it should be held valid. But then the court said, no, it is void under section 28. Okay, let's have a look at the facts here. The facts are quite straightforward actually. It involves both lawyers here, Wrigglesworth and Anthony Wilson. So both plaintiff and defendant, they were advocate and solicitor. Where? Okay, location in Kota Baru, Kelantan. And the plaintiff, Wrigglesworth, he was the sole proprietor of the legal firm of Wrigglesworth and Company. So it's not partnership, it's just a sole proprietor. Only one person own the firm. Okay, and then but he has employee, okay, to serve, to work together. So while defendant, okay, Anthony Wilson was the sole proprietor of the legal firm Wilson and Company. And actually, before Wilson and Company was set up or was established, the defendant here, actually, he worked with the plaintiff. So plaintiff was the former employer of the defendant. Meaning that here, defendant worked first to gain experience whatsoever, okay, with Wrigglesworth, and later he set up his own company. So they are now the competitor or rival. Guess why? It's the same, it's the legal firm nature, similar nature of the business. So let's have a look at the contract that they have signed, okay, which was involved at issue here. So on 20 September 1962, defendant Anthony Wilson, he entered into agreement of service with the plaintiff firm. So he wanted to be employed by Wrigglesworth. But then later, a year after, on 7 December 1963, plaintiff Wrigglesworth agreed to discharge the defendant from the terms and obligations of the said agreement with effect from 31st December 1963. So meaning a year after, a year plus. Okay? So the employer agreed to release the defendant from the employment. And then the clause which is in dispute here is clause 8 of the said agreement. It stipulated, okay, it stated that defendant shall not, for a period of 2 years after the termination of his engagement, meaning December 1963, by the plaintiff, December 1963, practice or carry on the business or profession of an advocate and solicitor within certain distance, within a radius of 5 miles. So 5 miles, if you Google, actually it is equivalent to approximately 8 kilometers, which is quite, it's not that far, okay? It's just within a short distance from Kota Baru town, without first obtaining the written consent of the plaintiff. But what happened was that Anthony Wilson signed the agreement, but later he breached the agreement. After all, he's no longer an employee of Wrigglesworth. So such written consent, he didn't get the consent. He just set up his own business. Such written consent has not been given by the plaintiff, by Wrigglesworth here. When defendant started his own legal firm, and then actually it is within 5 miles radius. Because why? If it is beyond 5 miles, then it doesn't affect the contract. It's not a breach. Here, plaintiff was saying, well, you breached the agreement because you signed, but you breached it later, even though you are no longer my employee. Now, Wrigglesworth, the plaintiff claims an injunction to restrain defendant from practicing or carrying on the business or profession of an advocate and solicitor within a radius of 5 miles from Kota Baru, Kelantan until 31st December 1965. Because why? When Anthony Wilson signed the agreement, it is to be enforced, it is to be valid for 2 years. Meaning that here, if only after 31st December 1965, you can start your own business within the radius of 5 miles. Okay? And then when the court examined all the facts here, and then after listening to arguments from both counsels, okay, actually counsel for the plaintiff, they try to persuade the court to apply the test of reasonableness, okay, the cases from common law. So the court said, the judge said basically, in my opinion, this case should be decided on the interpretation of Section 28 of Contracts Malaysia Ordinance 1950, that one before independence. Okay? And then the court said, they just said, with great respect, I do not think the English cases are applicable. So I don't want to refer to English cases. Meaning that we are not going to adopt the principle under English law. Because why? The contracts, Malaysia Ordinance 1950 is not based on the English law of contract, especially Section 28. And Section 28 is very, very clear. It's quite straightforward. Okay, and then meaning that here, whatever contract which restrain the profession whatsoever, it is to the extent void, except in the three exceptions. Okay, here, all right. And then the court said the defendant is an advocate and solicitor and can lawfully practice his profession in Malaya. There's no way that he should be restrained from starting his own legal firm. And the court said, therefore, in my opinion, any agreement to restrain him from exercising his lawful profession is void. And then the distance and place. Distance is 5 miles. Okay, place is within Kota Baru. In respect of the restraint are irrelevant. We are not going to consider whether it's reasonable or not. Okay, we are going to stop here. I'm going to continue in the second part of the lecture. So basically, this case, it explains to us the application of section 28, in which we don't refer or we don't apply the test of reasonableness, which is applicable under English law. Okay, with that, thank you so much. I stop share first. Okay, all right. So you're going to continue in part 2 of the lecture. Assalamualaikum warahmatullahi wabarakatuh.